I'm praying. Item number 3, Lordship. I'm praying on behalf of Learned Counsel A.K. Hussain, Lordship. Due to some personal difficulty, today he left, Lordship. Only for the day, Lordship. Tomorrow, Lordship.
Not a problem. This week.
On 5th, Lordship. On 5th,
5
Lordship.
At the replacement back to 5 9.
On 5th, Lordship. Deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention 3 criminal petitions arising out of the same FIR, Lordship. When on last occasion, these 3 cases are raised before the court, service was not completed. Now, Lordship, service has been completed, and in lower court also next week the case is fixed. So may I pray that these cases may be listed on Friday, next Friday. Today is Tuesday.
Monday 8.
On Monday. Obliged, deeply obliged, ma'am.
May I please, so I beg to mention regarding item number 31 of today's list, Lordship. This is a criminal appeal jail, Lordship. Here the paperwork which was provided to me is incomplete, Lordship, and I have compared it with the copy of the which of court, Lordship. That is different, Lordship. That-
Item number 31.
31, Lordship. That cross part of evidences are not there in my paper book, and pagination is also different. Yes, registry may be directed, and another aspect also in this case, amicus curiae is already appointed, but his name is not shown. Mr. S. Nawaz was appointed as amicus curiae on last occasion. His name is not shown in the cause list. That
But
registry,
you are also appearing for the appellant rather than amicus.
amicus, he is for the informant.
Yes.
This is POXO matter, therefore.
Item 31. Mr. A. Mr. R. Kaushik shall be given. It is submitted by Mr. Amit that the paper book of the applicant has been provided to the appellant, but it is not complete one, and pagination is also not tally with the copy of the paper book of the court. And accordingly, the rate for furnishing proper furnishing a fresh paper book with correct pagination and complete set of paper book with correct pagination. In this regard, the registry is thereby directed to furnish fresh copy of the paper book. Complete copy of the paper book with correct pagination. We'll stop further. Considering the submission made by Learned Counsel the appellant, Learned Counsel must public amicus, Learned amicus curiae for the appellant that the name of the amicus which have been appointed for the informant is not reflected in the cause list. In view of this, the registry is also hereby directed to reflect the name of the appointed amicus for the informant of the case. Release the matter accordingly after 3 weeks will do.
Here, Lordship, conviction is for 10 years and already undergone 4 years punishment sentence. Lordship. So at an early date.
So it has to come
After,
early date
after 2
cannot
weeks,
be because you have
only after 2 weeks that may be observed.
after.
And another aspect of that paper book, a copy of that corrected paper book may be furnished to the PP as well as amicus curiae for the informant.
So their copy is also different. Copy.
Different, that will be different.
Oh, same code. Copy of the paper book may also be punished. Corrected copy of the paper book may also be punished to the Learned Additional Public Prosecutor as well as the amicus.
How like it?
May I please?
2 weeks.
But you have recommended a criminal appeal for hearing, my lord, on 23rd. Criminal appeal, my lord. On 23rd.
23rd.
23rd. Highly of that.
May I please, Your Lordship? And I beg to mention for listing criminal appeal, my lord. The court already received, my lord. And the accused person is now 70 years age, my lord. He's serious ill in ICU, my lord, Shiksha Medical Hospital, my lord. So lordship may be listed on 9th, my lord.
No, the matter may reach or may not reach. We
On
cannot
9th.
say at this stage. Why don't you approach the registry so that in the court
Lordship,
of
Honorable Court directed after on receipt of the records for mention, my lord. That is why I'm mentioning, my lord.
So I cannot say it is of which year? Appeal is of which
This
year?
year, this year.
25.
Yes, my.
No, it's not about 25 only. It may be listed, but it may not reach. I
My lord.
think it is made, let it be on 16th of September.
My lord, I'd like to mention for listing on IA for correction of your lordship's order, your lordship. Bail order, minor correction, my lord. By tomorrow,
Right.
may be taken.
No, not tomorrow. We are not possible because we have having some matters from Itanagar bench.
My lord, day after tomorrow. Minor
Yes.
correction.
Day
Obvious.
May I please, Your Honor? My lord, I beg to mention item number 25, my lord. In this case, my lord, Dr. B. Ahmed is conducting advocate, my lord. But he could not come to the court due to various illness, my lord. So the petitioner wanted to engage another counsel, my lord. My lord, kindly adjourn for 2 weeks, my lord.
You are Mr.
M. Hussain, I am appearing on behalf of Dr. B. Ahmed.
That can just conduct the council to is the matter according to that.
Most obliged.
May please, your lordship. May please, your lordship. I beg to mention a criminal event petition for listing, your honor. May it come up on 5th of September. The lower court case is fixed on 9th September. So maybe
It's almost full.
any date before 9th.
Fifth is almost full. Your lower court matter fixed, it doesn't matter. You cannot tell. Once 16th of September, somehow you manage one date.
Obliged.
May I please, Your Lordship, I beg to mention for listing of a criminal petition for tomorrow, Your Lordship.
No,
The urgency is that someone has been issued for 4th.
that is your problem. We don't have any space. If tomorrow is not at all possible. At
Day
least
after
maybe on the 9th of September. 9th of September.
Lordship, my lord, I beg to mention for listing of a IA in criminal revision, my lord. That is convention petition, my lord, supposed to listed after 4 weeks. 4 weeks already passed, Your Honor.
So what to do? We don't have any more time. 4 weeks past is past. You can very well approach before the registry. So now we may order, but I don't think it will reach now. Okay, maybe by 9th of September. 9th of September.
May it please your lordship, I'm praying for listing 2 criminal revision petitions. Both are connected cases and for admission may be fixed on 10 September.
11th September.
Please, your lordship. Lordship, I beg to mention item number 14, lordship. Lordship, conducting counsel could not appear today due to some difficulties, lordship.
Mr.
Lordship.
Kapoor,
Lordship, yes, my lordship.
Yasmin.
Yes. Lordship, may fix the matter on
Yes, go ahead.
any date before vacation, lordship.
Sorry. Date you want?
Any date
No,
before.
2 weeks after 2 weeks.
Lordship, a fixed date may be given kindly, lordship.
No, 2 weeks as on date.
Deeply aware.
May I please, your lordship, I beg to mention item number 32. Okay, with the consent of the respondent number 2, I beg to mention for adjourn, lordship. Madam,
You have taken consent of the other side.
respondent number 2, lordship.
32 with the consent of the.
So, madam, I will-
respondent. The appellant side to be for determined, very proud. Is the matter according after 3 weeks. It will be listed after 3 weeks. As
That's-
on a date.
After puja vacation, after puja vacation.
After puja, immediately after.
Much obliged.
May I please, Lordship, I beg to mention for listing to criminal revision petition, Lordship, for admission, Lordship.
One six, 16.
Obliged.
May I please it your lordship? Lordship regarding item number 24,
Hmm.
requesting to adjourn the matter for actually senior is unable to appear today because
24.
of personal difficulty. And also, we are not connected with the accused also from few days. That's why we don't have the exact details.
See, this is a case of 2012. Only next week we are listing the after 2
Yes.
weeks. Try to get it.
Keep your blessed, Lordship.
2 weeks. Engage council, your engage council, just a second. Your engage council is,
Lordship.
who is your conducting council? Conducting
Is
council,
it, is it,
PJ,
is it
PJ Fukan. 2 weeks.
This is second round of lordship application lordship. Earlier order lordship at page 80 started page 18 lordship.
8.
Page 18 earlier order lordship. FR was registered lordship under section 80 of BNS lordship dowry date.
Dowry date.
Dowry date lordship. At the time of passing order lordship, FSL report was not received lordship. Therefore,
Up to the city may be confirmed.
lordship, one affidavit we have annexed along with this lordship. This affidavit, one affidavit is annexed at 3 lordship. It was executed by lordship informant itself lordship. The informant lordship is the lordship brother-in-law of the accused lordship, and he lordship do not want the arrest of this accused lordship.
I know one person died. Right?
He is interested, not interested, we are not concerned.
Yes, madam.
When it can be fixed?
But for Morrigan,
Morrigan.
10 days needed.
Within 19 days it will come, I think. 10th of September will do. 10 9. 10 9. 10 10 9. Updated case diary along with your system. Appears on this the matter.
May I please, Your Lordship, this is an criminal petition for quashing of an order. The FIR is in page 10. The brief of the case is that PMAY funds were released to 41 people and after the block development officer went to the premises for verification, it was found that no construction was done at that relevant point of time. Subsequently, the construction was done, and upon receipt of the FIR, the case was registered and it's pending adjudication as such. And now my petitioner, he has received, he did not receive any summon, and subsequently non-bailable warrant was issued. It is the first occasion of non-bailable warrant, Your Lordship. But we are, as we are not physically fit, we seek the protection of this honorable court and we want to appear and face the trial, Your Lordship.
So your petition is was shown as an abscond.
Absconder.
He was working as a under what strength?
Lordship.
Said block development of he was a employee or
No, not an employee. He was a beneficiary, Your Lordship. He was a beneficiary of the scheme, PMAY, the house scheme.
he is
Awas
also
Yojana.
the beneficiary.
He is one of the beneficiary. Later on, subsequently, he has built up the residence. We are ready for any sort of verification, Your Lordship. At that relevant point of time, when the verification was done, his construction was not completed as he was out of station. Subsequently, he has completed the construction also.
There are slab, I think. There are some slabs, I think, in that slab. the money is released.
Yes, your lordship. The first slab was released. 1,30,000 was released. And the entire was utilized for construction, whatever construction has been completed, and he's ready for the verification. At that relevant point of time, he was not
Where is the
available.
order sheets?
Well, kindly peruse page 43.
43.
Last paragraph.
Yes.
Payable warrant was issued, that was executed.
That was
even-
written after execution.
Yes, even after that, my lord, he.
Your lordship, at that point of time, annexure F, page number 48 may be perused, your lordship. He was undergoing treatment. He has some very serious abdominal issues, probably gallstones and all, your lordship. That's why he could not appear. Now he is willing to appear, and he will face the trial, and he will appear on every other date, or any conditions may be imposed, your lordship.
This is not a medical document, my lord. Just,
This is a prescription, your lord.
14.
this is not a prescription, my lord. This is not clear and this is not a prescription. This is manufactured.
We are ready to face the trial.
PNA is also issued.
PNA is not issued on.
DNA against him not issued.
PNA is issued
Against
against
others.
Yes.
Others.
41 accused are there, your lordship.
So your petition name is?
Asmat Ali. Accused number 19, your lordship, page number 19 of the petition. It is the charge sheet.
Yes, medical document, my lord. Kindly go to the medical document. It seems when it is manufactured, my lord. No specific, nothing, my lord. Just to,
Even though not relying upon the medical records, we are ready to face the trial, your lordship. We want to appear before the court and face the trial.
For hypertension, what kind of treatment he was undergoing?
nothing.
And abdominal issues as informed to me, your lordship.
Who gave this? Doctor and get the doctor's house for some money they are doing this. Certificates are. But can it come? Lots of and it is submitted by Mr. Modi. This is in the picture. Next one. It is submitted by Mr. Modi. It's a innocent. Because during the inquiry, the house which was allotted, the name of the petitioner was struck due to his ill health should be because the liquid with health issues. When utilizing the government fund, he had already constructed the house. If people search for during the investigation, then not dependency of this case. Dependency of this case. However, one BW was received by petitioner due to his ill health as he was suffering from some abdominal issues, could not appear before the learned court below. However, at present, the accused NPWA is issued against the present petition, but he is ready and willing to appear before the learned court below, learned trial court below, and contest the case. If he is provided with some information. Mr. Kaushik Irani some that even after available warrant, the accused petitioner remained absent or the NBW had to be issued against the present petition, and thus is no illegality committed by Learned Act. He may be directed to appear before the learned court will with an appropriate application. But he may not be provided with any interest. Next, getting the submission to provide an the case record and the pictures file along with the petition. And it is seen that APW was indeed executed on the present petition. In spite of that, he made absent for the court, and according to court had to issue NPWA. However, the petitioner took the plea that he was suffering from acute abdominal pain, and for which he could not appear. And at the same time, he also pleaded that he was never switched by its during next considering all these aspects of this. The petitioner is thereby asked to appear before the learned track with an appropriate petition for bail, which may be considered inappropriate. However, till when your next date is fixed now,
16th of this month, Your Honor.
however, till 16/9, that is still next date of listening, the execution and PWA issued against present petitioner be stayed.
Highly appreciated.
Till next date.
But
Till next date.
no, 16/9 is this, it is disposed.
Highly applied.
May it please your lordship. Lordship, impugned order is at page 30, lordship, wherein the first NBW has been issued. Lordship, petitioner has 4 dates has been defaulted, admittedly default, and that I have stated in para 15 of my petition that due to some miscommunication with the engaged counsel that has been defaulted. Now, lordship, page 35 is the next date of appearance, lordship, 10/9. So, Lord, they are in a course of regular attendance, lordship, where 4 dates has been defaulted. Now they are willing to participate, lordship. My prayer, lordship, that the warrant, execution of warrant be kept in abeyance, and they will appear before the
First order to go to.
first order to step slow, and I hit on page 30.
The petitioner's name is
Lordship,
Samir Ali
Somera
Samir Ali
and
and
Noor Islam.
and
Noor Islam.
Noor Islam. Here also they were repeatedly absent, but they were taking steps.
steps
Taking
taken,
steps.
but they did not physically appear.
Yes. And it seems, my lord, no available warrant was issued prior to that.
Pardon?
No available warrant was issued prior to that, it seems.
Oh, available warrant not issued because they
They were taking steps.
were present.
Taking steps.
So as per you, how many days you defaulted?
4 date, lordship.
Since when?
Since 2025, 25, then the next date was fixed on 22/4, then 13/6, and then 29/7. And next date is 10/9.
Artemis Song, the language this submitted by Mr. MS Song that this petitioners, both the petitioners were represented by by Catholic Council regularly since 7/3 2025. But on 7/3 2025, due to miscommunication with the and Wisconsin, steps could not be taken for them and for which they were reported in four occasions and NPWA were issued against food. But they are unwilling to appear fully and to tickets if they were provided with some information. In that context, Mr. Kaushik Tilani something. Petitioner may be directed to appear before the landed trial court below without any interpretation. Without any interpretation and their application considered in a court. Submission of constitutions and also various annexes, especially the operations and considering the submission made by London and considering the absence of the goods petitions and coordination and other aspects of this. I find that I hereby direct the both the petitions to appear before the London trial court below. Sit and application may be considered in accordance. However, till next date of listing, that is on 10/9, the command the NPWA issued against the petitioners may be kept in abeyance. The petitions. It will be kept in abeyance. It can appear and regular failure.
I'm deeply obliged.
May it please the lordship. An application under section 5.
6 year appeal.
Your lordship.
Oh no, you just
An
appeared.
application under section 528 of BNSS lordship. Impugn order dated 5/8/2025 lordship, passed by the learned SDGM Kamrup M lordship.
Report may be called from seeking Jimma.
Order dated lordship.
Case of? You need what is this period?
60 numbers of cattle seized by the investigation of Your lordship. Kindly see the order dated 5/8/2025, page 16, your lordship. Petitioner is the owner, your lordship. That was reflected by the order, your lordship.
So you are seeking Jimma or what you want?
Jimma, lordship.
Oh, Jimma.
Yes, lordship. Kindly see-
Presently, these cattle are in Jimma in any foundation or where they are now? These cattle,
Cattle, lordship.
where they are kept?
They are
At present?
traveling from Bopara to
No, at
Murgaon.
present, those cattle were kept in which?
Goshala, lordship.
Goshala.
Yes, lordship. Out of 16 cattle, lordship, already 3 cattle were died, lordship, due to health issue, lordship. Kindly see the order dated, your lordship, page 16, lordship. And accept 3, lordship.
Now it is the reasons are being brought in the order itself that those cattle were being transported to Meghalaya.
No,
On the way to Meghalaya, only those were intercepted. That is not permissible, I think,
Yes, not
for the purpose of slaughtering.
no, lordship.
Some conditions, some requirements are there to fulfill.
Requirements are there, some requirements are there. I don't know whether you have complied with all those requirements. Otherwise, you cannot transport the cattle for
Actually-
slaughtering to other states.
Actually, lordship, they were traveling to Morigaon, lordship, to Restart Market, lordship, from Bopata to Morigaon, lordship.
Not to Meghalaya.
They are not transporting to Meghalaya, lordship.
But the order says so. Anyway, we need a report.
Kindly short date may be given a lordship,
Sure.
if possible, lordship.
We will report them call for from the concerned station. This is an application under section 520 appearing against the influence order dated 5/8/2025 passed by learned SDGMS Kamrup number 1 Kamrup Metro in while disposing the petition number 4117 2025 alleging got you PS case number 230 by registered on the section 13 subsection 1 of Assam Cattle Preservation Act 1. Read section 11 of the Prevention of Cruelty to Animals Act 1960. Report be called for accordingly as to whether the cattle can be given to the present petitioner who is claiming himself to be the owner of those seized cats. The external PP will take necessary steps. Yes, when it can be.
Any date, my lord?
Lordship. And it's for that, Lordship, already,
A report. 10th of September. 10th of this month.
oh, obliged, obliged.
May I please, your lordship?
Yes.
So lordship, this is an application under section 528, your lordship, paying for quashing of impugn order dated 26/4/25, which is at present pending before the learned trial court, your lordship, JMFC Golaghat, your lordship. The FIR is at page number 26, your lordship, annexure 2. If I may read, your lordship. With due respect, it is stated that my son, namely Imdadul Haq, went to Golaghat district for working purpose to seal electric post under HB Construction Company. At the time of loading post, a Tata Magic vehicle, due to carelessness and negligence of the company, the electric post fell down from the vehicle on the head and chest of Imdadul and succumbed to his injuries. The date of death is 12/3/25 at 6 o'clock in the morning. Unfortunately, it is stated that nobody of HB Construction came to the house of Imdadul Haq to meet his family member. Imdadul left a son, so and so, your lordship. Thereafter, the IO, your lordship, after investigating the case, has filed the charge sheet, your lordship, which is at page number 38, annexure 3, your lordship. And the charge sheet was filed against the owner of the company, Harshjyoti Boyso, and two other accused, your lordship, who are the petitioners in this case, and they are the employee of the HB Construction, your lordship. And most interestingly, your lordship, if your lordship would peruse page number 44, your lordship, the present accused petitioners, your lordship, they are also shown as the witness in the instant case, your lordship, at page number 44. Santanu Sharma, who is the petitioner number 2, and Aminul Haq, your lordship, petitioner number 1, your lordship. Thereafter, the learned trial court, your lordship, by order dated 24/6/25, has taken the cognizance in the case and issued summon to the accused petitioner, your lordship. Your lordship, from the FIR itself, it is very much clear that there is no such allegations against the present petitioners, your lordship.
PW number,
PW number, your lordship, 5 and 6 at page number 44.
5 and 6.
5 and 6. They are also shown as the witness, your lordship, in this case, also the accused, your lordship. And your lordship,
Accused number?
accused number 2 is PW6 and, oh, sorry, your lordship, petitioner number 1 is PW6.
No, not PW. Accused number.
Accused number?
You are, for what you have come?
Your lordship, to stay the order dated 24/6/25.
No, I'm saying.
I'm coming.
You were saying once you were saying.
I'm
that
for
those are
Santanu
5 and
Sharma and Aminul Haq, your lordship.
It's okay. 5 and 6 are shown as an these two the witnesses.
Yes, your lordship. And they are also shown as
5
accused number 2 and 3, your lordship, in that charge sheet.
And that's what I.
Yes, your lordship, accused number 2 and 3. 2 and 3, your lordship.
No, there is no illegality in the order, my lord.
Order is at page?
Order is page, my lord.
Order is at page
6.
47, your lordship.
47, my lord.
And your lordship was pleased to stay the case against the owner of the company, Harshjyoti Boistoy, your lordship, accused number 1, which is at page number 48, your lordship, annexure 5.
Just pay, if the order is the pay.
Page 47.
It's near the submission.
Yes, your lordship, from the FIR itself, your lordship, it is very much clear that they have no role in the incident, your lordship. They are just the employee of that company, your lordship. And your lordship has already observed in the order dated 28/7/25, your lordship, wherein the case was stayed against the accused number 1, Harshjyoti Boistoy, your lordship. There should have been direct connection in between the petitioners and the deceased, your lordship. Unfortunately, that incident happened, but they are the employee of that company, your lordship.
Order was passed, Mr. Kaushik, in regards to one petition of accused number 1.
Yes. But
This-
whether these persons are in the same footing or not, I cannot say at this moment.
This is we also cannot see,
Yes.
because as the owner, his presence may not be there, but as an employee, they may be there, that we cannot.
They were also employee and labor, your lordship. They were at the site, your lordship, and there were various other persons. Only the allegation in the FIR is that HB Construction did not provide any, your lordship, safety measures. So they are not responsible for that, your lordship, and they do not have any direct connection to that incident, your lordship.
Artist as with that considered petition and also parties with circumstances. Is submitted by Mr. Paul that accused petitioners are only the employee of said construction company and they are no way related to the in which they were also, though they are the accused number 2 and 3 in the chart, they were also shown as an PW number 5 and 6 in the chart sheet. Submitted that that the being the employee of the labor of the company, there has no direct involvement for the death of the deceased and no rash or negligent act was on the part of the present petitioners for the date of the accidental death of the deceased. Only submitted that the order proceeding against these 2 petitioners may also be stayed in the further submitted that the one of the co-equals, which is the owner of the company, had already applied for this court and by order date 28/7/2025 in case number.
Your lordship, criminal petition 882 of 25.
Criminal petition
882.
In criminal petition number 882 of the 25. A further proceeding is use number 1 is also state. And considering the case of the present petitioners in the same footing, further proceeding against these 2 petitions. So accordingly, how many accused persons? Only 3 accused.
3 accused persons.
In that context, Mr. Kaushik, the learned counsel PP submitted that there no illegality has been committed by the learned trial court below while taking cognizance against the accused persons and considering the merits on the record. And the cognizance was taken, finding a privacy case against all the accused persons. Next, hearing the submission of the learned counsel. Further proceeding, with PRC case number 181/2025. The state will next also for the scan. Here you have made the party, this is other person.
Pardon, Your Lordship.
Informant is made party here.
Yes, Your Lordship.
No comment. Please start.
Deeply acknowledged.
Please scan performance.
May it please your lord. This criminal petition is filed under section 528 for quashing of a PRC case number 1652 of 2025, presently pending before the Honorable Court of the JMFC, Kamruk Metro, Your Lordship. Actually, Your Lordship, due to a marital discord, the petitioner number 1 has lodged an FIR against the petitioner number 2, that is husband and wife. And this subsequently the charge sheet has been filed and this PRC case was registered. And she has also filed a DB case, Your Lordship. And subsequently, Your Lordship, during the process of this DB case, they have amicably settled their dispute. The petitioner number 1 already left Guwahati and presently she is staying with her husband in Visakhapatnam, along with 2 kids, Your Lordship. Now, therefore, as they have amicably settled their dispute, Your Lordship, they wants to quash this PRC case, Your Lordship, presently pending in the before the judicial magistrate of the Kamruk.
Petitioner number 1 was the victim.
Yes, Your Lordship, she is the wife. And petition number 2 is the husband, Your Lordship. And if Your Lordship will see page number 24. Page number 24, that is the DV case, which they have already withdrawn, Your Lordship. They have filed a joint petition at page number 25 before the court. And they have amicably settled their dispute, Your Lord.
The this quashing petition was earlier dismissed, I think, na?
No, Lordship.
Was there any earlier quashing petition?
No, Your Lord. This is the first time we have approached this honorable court, Your Lord. Earlier, actually the husband has approached earlier for quashing of the DV case, not for the PRC case, Your Lord. So, and that petition was already dismissed by the honorable court. That is relating to the DV case on, not for the PRC case.
Because I can remember the
Yes.
names, then remind me that yes, I have disposed one petition. I have already disposed one petition. with
Yes,
these two
yes, yes.
parties. That is,
oh.
I still can remember.
Oh.
That's why I'm just asking.
Oh.
So one petition for quashing was there for DV.
Yes, earlier they have approached this honorable court for quashing of the DV, which this honorable court has rejected his prayer, the husband pay. And subsequently, they have amicably settled. Mediation was going, was directed by the honorable court. They have settled their dispute and she already left the Guwahati. If your lordship will see page number 7, I have made an amendment that serial number 2. Page 7.
Yes, Kaushik.
Otherwise, we are formal party here, but it seems that they relying on forward fight has been.
So what was the stage of the case? At present, what was the stage of the
Appearance,
case?
appearance of the husband, you.
Appearance.
Yes.
Part MS and it counted for the petition. And also part are not Kaushik and the session. We have stated one. This is an application, section 7, condition is for questions. It is submitted by MS Queen that okay, is the petition number 1 is the victim of the informant of this case, and the petition number 2 is the accused case who jointly filed the present petition. Was there any other accused person?
No, no.
Only he is the sole
Only he is
accused.
the,
Only accused.
yes, petitioner number 2.
Jointly filed the present petition for washing of the charge sheet number 2024, dated 31/5/2024, arising out of all Roman police station case number 28 of 2023, which was registered under section 498 IPC, and also paid for washing of the further proceedings of PRC case number 1652 2025, pending before the learned JMFC Kamur and Guwahati and section 490. Is submitted by MS Queen that due to some matrimonial dispute and misunderstanding, an FIR was closed by the petitioner number 1 before the all women police station, but subsequently and one BB case was also initiated by the present petitioner number 1. However, during the pendency of the DB case, the matter has amicably settled between the parties, and in pursuant to the settlement, we have approached the court, and the case was accordingly referred for mediation, where the matter has already been settled in the DB. Next one, the present petitioner number 1 also presently staying with the petitioner number 2, and she already left the place of Assam, and at present she is staying with her husband of the accused at Visakhapatnam, Andhra Pradesh. As both the petitioners have amicably settled the matter, there is no chance. The chance of conviction is very remote and big, and in this case cannot be expected. The petition number 1 will be posed against petition number 2, even if case is allowed to proceed in the college committee. Doesn't do side or some. Okay, it will be discussed.
Obliged.
May I plead your lordship, in a petition under section 528 of the BNSS Act, my lord. FIR is, my lord, page 9, my lord, annexure 1. my lord.
My lord, here before. The POXO case is, POXO is there, my lord, so this would go at this.
My lord, fact of the case is that FIR is
So is
legally
the-
false, my lord.
Right.
We have to issue notice.
My lord, interim protection may be given, my lord.
POXO we cannot ask him. Have to issue notice.
I so and so, son of so and so, dealing in gems, jewelry, and allied products. I have filed this case against Sri Mukesh Sharma, proprietor of Messrs. So and so, who purchased taxable gold jewelry on credit worth rupees 6,05,412 in April 2021. An outstanding remained in his account is 7,58,353 in April 2023. Tax invoice and ledger account is submitted. After a considerable time, when I requested him to pay, he refused to pay and threatened me of dire consequences, and that is why I lost the case. But on the basis of this deposition alone, my lords, the cognizance has been taken. Now, my lord, if your lordship will find the complaint, which is that page, my lord, 13. Well, the petitioner is a person residing at Lakhimpur, my lords. He is beyond the territorial jurisdiction of the learned trial court. And in such an event, my lord, the learned trial court should have resorted to the procedure under section 202 CRPC. My lord, that procedure is a mandatory procedure. Number of judgments of the coordinate benches up to the apex court, my lords, are there. The stage of the matter even does not, my lords, is not really an issue. Because the lordship will find at page 13 itself that my address is given, Messrs. Assam Fancy Jewelers, proprietor Shri So-and-so, KB Road below Indian Bank, ward number 13, Pure North Lakhimpur. My lord, the order of cognizance itself is bad. And therefore, all other proceedings, without going into the aspect of, my lord, today, whether the complaint is based on a civil issue or not, let's prima facie this proceeding, my lord, as of today is bad. Because it arises out of the order of cognizance dated 14/11/2023, which is contrary to, my lord, section 202 CRPC. The corresponding provision is also there in BNSS, my lord, 225. So today, my lord, I would humbly request that your lordship may kindly stay the proceeding, issue notice, and then my lordship will take it up on some date for admission hearing.
Case number 4 and order reporting and see Kamrup JMFC number 1 Kamrup has section 4.506 against it is submitted that issue notice to the respond to register AB and as usual also corporate can. It was submitted by Mr. Kanpuri that the present that the from the plain reading PFI itself, it reveals that the cases of civil nature, and the property the parties can very well for the civil court for advocate review. But he submitted that the cognizance the cognizance was taken against the present petitioner. It is ordered by Senate trial court below. After recording the statement of the complainant under section 200 CRPC, from the address to the respondent petitioner, it reveals that he is the resident of Lakhimpur. The company is at somebody is at Lakhimpur, but without taking the result of section 202 CRPC, cognizance has been taken against the present petitioner. Only recording the statement of the complainant under section 2 CRPC, for which the entire proceeding is vitiated and I will satisfy. We are issuing notice at that.
No, there has to be an order of stay, because the matter is day after tomorrow fixed on 4/9 for evidence before charge. Prima facie, my lord, I have shown that the order is bad.
But number state. Matter recording.
I'm deeply.
The petitioner has expired in the meantime.
Oh.
So matter has written in particular.
In particular, in a sense, do you have anything to submit before?
The matter has
Any
become
date
factual.
certificate and all?
My lord.
Any date certificate?
No,
or
he has
you have?
expired 2-3 days back, my lord. That I'll produce before the trial.
You are Mr.
B. Chakraborty.
submitted by Mr. Chakraborty that 2-3 days back.
4 days back,
4
exactly.
days back, petitioner died. And hence, it does not want to proceed with his partner according to the report. However, Mr. Chakraborty has submitted that the death certificate, etc. May be required, and those will be furnished before the health. Considering submission made by stands this both. Fifteen you are appearing. You Yes, Council, you are appearing point 15.
Yes,
I don't
Lord.
know. Yes, what is the
Perhaps my service report is awaited. The POXO,
service report is awaited. It's
Lord,
POXO.
POXO, my lord. Yes, our seated case.
Lordship, kindly very short.
No, it's okay, 13/25. So what don't you want to submit here?
Now, you're,
Status report.
because one is absconding, my lord. Earlier, we came before your lordship with a AB, your lordship directed to appear within 15 days, we appeared. Thereafter, you are taken to custody, my lord.
Why we have not received here,
Yes.
Sami?
Lordship.
And
We need
but
to give the status report.
Status report and my lord, CD,
again and again, my lord.
CD or case record?
case record, my lord.
Case record. Why it has not been received?
Not been issued.
But again and again, your lordship kindly give some so that it may come immediately. Otherwise,
Again and again means I cannot.
but earlier also, earlier we came. Your lordship was directed, my lord, directed to appear before the court below.
Oh,
We-
acha.
We appeared.
It's man.
That, huh?
Page
Page, earlier got page 37. AB, your lordship. Oh, sorry, that was BA,
As
It is
charges was filed, you were
certificate.
directed.
Yes, tax sheeted.
It is
Tax sheeted, but
certificate.
charge not framed because one is absconding, my lord.
Acha.
And 2% absconding. So how long will we, my lord, waiting for that? That
TCR
is the
may
only
be-
case, my lord.
TCR can be maybe called out for registering.
This year we are calling for.
This earlier also registry was, my lord, directed. And that was the order dated 13/8, my lord.
Copy already accepted.
The charge topic, the
Huh?
senior Mr. I-
By Vasile,
बहुत कुछ एक बोल रहे हैं।
pending me.
ये लोग मानता था मुझसे।
But of people, they will-
the this note is simply
Original है ना,
that
which can be-
But may, only one thing may I point out, one.
is not dated 38.
Is that one is can put to us over there. That's what scan को page 37 it will dispose into official record of copy of it. But we don't talk about registry. Have been looking me. When this one. Thing. Done on.
The operator is dated 30, it is in the status still so the registry of the consent by the consent secretary. Mr. Chaudhary, it means is submitted that that the accused is in custody for considerable period and due to absence of one of the accused who was shown as an abscond case also could not be proceeded and for no proceeded in view of this the registry is thereby directed all for the scanned copy of the DCR along with the case diary as well as the status report of the case and the the record should be reached before this court on or before the next. The same record. Sometime may be given from where it is Sribhumi, but yes.
But one thing my point out, madam. In page number 37, scan copy was called for in another case. This is here in the registry, ma'am. So
Oh,
can
it
copy,
is-
yes, madam.
Okay.
That BA number, you also can page 37. So that this also may be called in the status report also may come, madam.
BA 390.
BA,
Help you.
BA,
This
please, madam.
7 will not help you.
Oh.
We don't know what, this was called for prior.
Earlier,
Earlier, I think.
prior to
Same case in another petitioner, madam.
No, same petitioner.
307, my lord, 3907. BA number 390724. In this case, my lord, scan copy was called on 2525. Your lordship disposed that, directing to appear before the court below. In that case, scan copy was record.
So that
Scan-
scan copy will not help you, that's what I'm saying. May have not help.
It may not
Because
may not
see
be
that
up to date. May not be up to date.
one petitioner is still absconding. That
Two
petition
petitioners,
has to be
two persons are absconding.
absconding.
My name only matter if possible matter for if possible matter for short date matter because your lordship
Short date. That's what
scan
I'm
copy they
saying.
can by telephonic.
We not-
I understand your lordship difficulty matter. We
help you,
also,
I think,
but here matter.
at least it can be on 18 or 19 September. 18 or 19 of September.
I
That
left your
apart,
lordship.
don't
I
have
left
it.
your lordship matter.
18 September.
Obliged.
We'll try to get.
Only they have to dispose my petition pending there matter. This is the case.
What is the petition?
Petition I have given for splitting up is per your lordship direction. That
Oh,
your lordship mentioned in your lordship's idea.
acha.
After you dispose that petition, only, you take a decision on that petition. That report your lordship was pleased to call. That is the idea.
Better.
Yes, ma'am.
Praise your lordship. My lord, I'm behind the bar for the last 77 days. I'm behind the bar for the last 77 days. Only 13 days to complete the statutory period, that is 90 days. And 30 days will be completed by this 15th September for 77 days. My lord. Already this, I approached this honorable court. Lordship, kindly have a look at the last order, page 41. Only 2 paragraphs I'll read. Already this honorable court has recorded. Page 41. Paragraph 4 and 5, I read, my lord.
Yes.
May I read, my lord? It is submitted by the Sir Learned Senior Counsel for the petitioner that the present accused petitioner is innocent and he has not committed any such offense as alleged in the affair. However, coming to know about the misappropriation and missing of gold from Asirvad Microfinance Limited, the petitioner himself, my lord, voluntarily cooperated in the audit proceedings. During his name has been entangled in the present case. Mr. Swencho further submitted that the present accused petitioner has been in custody for the last 44 days, including 3 days of police remand. However, from the order passed by this learned trial court below, it reveals that the 3 days of police remand, no further prayer for custodial remand was made by the IO, my lord. He further submitted that there is a sufficient progress in the investigation and hence further custodial interrogation of the present petitioner may not be required for the purpose of investigation. Paragraph 5, my lord. The Learned Senior Counsel, citing the decision Honorable Apex Court, Sanjay Chandra Swencho. The father submitted that the provisions of the CRPC confers the discretionary jurisdiction on criminal courts to grant bail to the accused pending trial or in appeal against great prayer and caution by the balancing the available right of liberty of an individual and the interest of the society in general. He further submitted that it is a settled position of law that the bail is the rule and jail is the exception. Further, he submitted that a person may be put into jail pending trial only to secure their attendance at the time of trial or at the time of investigation. But here in the instance case, the present petitioner himself voluntarily surrendered and appeared before the audit committee and also cooperated with the audit proceeding, and thus there is no probability of the absconding of the present petitioner who himself appeared before the audit committee is still ready and willing to cooperate with the IO in the further investigation of the case. This is my learned senior on the last occasion, my lord. This is by submission required. Admittedly, my lord, today is the 77 days. I voluntarily went, affair lost on 16, my lord, 14. On after 2 days, I voluntarily go there and surrendered myself, my lord. And my lord, after my
when the interrogation done, my lord, it is recorded here, my lord. On my interrogation, other co-accused name, from myself, I had stated that these persons are involved in this matter. Then, my lord, lordship has rejected, my lord, at page 44, my lord. Para 8 and 9, my lord. It is a settled principle of law that the bail is a rule and the jail is an exception. However, the seriousness and gravity of the offense are also relevant consideration while deciding a bail application. In the present case, the materials on record of prima facie disclosed that the accused petitioner, in a connivance with the co-accused persons, not only defrauded the financial institution but also betrayed the trust and general public who had deposited their gold with the said company. Well, I'm sorry, my lord. In paragraph 8, already the Honorable Court, after perusal of the records of the swing, it is prima facie, it is established that yes, present petitioner, including the other co-accused persons, are involved in this case, yet they defrauded that the concerned institution, my lord. That means on merit, lordship has recorded it. On merit, that means I have to face the trial. Next course of action, whatever in the trial, I have to face, my lord. Now paragraph 9, my lord. In view of the above discussion and also considering the gravity and the seriousness of the offense, the manner in which the public trust has breached and the role attributed to the petitioner in the commission of the offense, and further considering the fact that investigation is still under progress, I find that the further custodial interrogation of the present petitioner may be necessary to unearth some more facts of the case and also to name some other culprits who are also involved in the present case, and therefore I do not find it a fit case extend the privilege bail to the accused at this stage, and according to the same stand rejected. My respectful submission before this honorable court, my lord. Then, my lord, since for the last 77 days, I am there, my lord. I am the accused number 2. Here is the admitted name with the prime accused is the Moon Ahmed, accused number 1. Till late, when the authority failed to, he's still absconding. He's no way, if state authority still failed to arrest him, but with the people admitted, we admitted, my lord, we are also involved in this case, my lord. But for that person, they failed to arrest him. But for this only the reason, my lord, we have been behind the ball for the last 77 days, my lord. Why we have been only 13 days? They have to complete my statutory 90 days, my lord. So my respectful submission, since they failed to do any 77 days to arrest the accused, what they will do in the remaining 13 days, my lord? On 15th September, 90 days will be over, my lord. Since I myself surrendered before this court, it is some, since I myself surrendered, that means some from the state authority, I must get some additional protection, my lord. So my humble in this case, that's because of, my lord, regarding to offense, I am involved in this case. I am absolutely ready. I am bound to face my trial. But unnecessary, I am keeping for the last 77 days, my lord, for further 13 days, keeping me behind again, my lord, against absolute violation of Article 21. So my respectful, I made this, my lord. If the learned friend, my lord, today this one got directed to update case that be placed before this court. Since after it is now 18 days when lordship directed on 14 August 25 directed to place the case diary. Now after 18 days they failed to produce case diary. No, for this reason, my lord, I may not be keep under the detention, my lord. I may be enlarged on release on bail, my lord. This is my submission, my lord.
Firstly, Lordship, I wanted to say here, Lordship, as it has been already been rejected earlier, Lordship, and otherwise the materials are sufficient prima facie materials has been there.
Yes.
However, this is second ground, no new ground has been given or cited before your Lordship. Lordship, after looking into the CD, it has been rejected. If he wants to go into merit, I can go into the merits of the case, Lordship. First, I have not found any new grounds, Lordship. Secondly, if I want to go into the merits, Lordship, this is the person out of which there are 19 families are there, Lordship, who has deposited gold, Lordship, and take loan, Lordship. And they have, what they have done, they have take out from the locker, Lordship, this gold and sold it in another places, Lordship. And they have in 7 or 12 occasions, in 12 gold, Lordship, they have misplaced with fake gold, Lordship. And this person, this petitioner number, this is 17, Lordship, item number 17, Kuldeep Deka. He is the assistant, Lordship, assistant head branch manager, Lordship. And according with him, Lordship, there is another person who is branch manager who is Moon Ahmed, Lordship. They criminally conspired these three persons, Lordship, Kuldeep Deka, this woman lordship, Ria Paul, and another Moon Ahmed lordship. What they have done lordship, and this person's, the Ria Paul, in his house lordship, matrimonial house, 6,38,000 of gold has been found, which has been of this lockers lordship, gold. And moreover, lordship, it has also been stated that lordship, the transaction, account transaction lordship of the Moon Ahmed, these persons, there are illegal transactions are there, which is unaccounted to their account income lordship, disproportionate to their income lordship. However, moreover, lordship, this gold were deposited in other companies in fake customers' name lordship, in Ria Paul's case, lordship. And however, in this case, there are CCTV footages are also there, lordship. What else need to be there, lordship? So
Lordship-
CCTV footage, lordship, let me complete first. There are CCTV footages are there where it has been seen that 2 packets of gold from the vault area has been taken out and he put in his pocket lordship. And moreover, what else is needed, lordship? He is 2 keys are there. One password keywords also there, lordship. He knows all these things, lordship. And these persons and with the Moon Ahmed, these 2 persons are there. Prima facie case has been established, lordship.
Moon Ahmed could not be.
Moon Ahmed cannot be apprehend, lordship. And otherwise, moreover, out of 19 golds, lordship, which is about 888 grams, out of which only 13 pieces of gold were found, lordship. And this amount, whole amount leads to be 74 lakhs, 49,000. This is of a common people gold, lordship. They siphoned it off, misappropriated, criminal breach of trust is also there, lordship. And they are stating that what else we will do. I have objection, lordship.
Yes. Lordship, my submitting things to reply, my lord. I appreciate my direct friend, his state, he vehemently objected on this, my prayer, my lord. Since, my lord, and the prima facie, my lord, in paragraph 7 and paragraph 8, lordship is already on merit, lordship is recorded, my lord.
Now,
Same
just
submission, my lord.
tell me one, Shraddha.
Lordship.
Obviously, there are merits. I have also gone through them, still I can remember.
Lord.
It's a case of wherein the deposited golds were been, and where it was misplaced with some fake golds and all. Those kinds of things were there. And as they have submitted from Ria Paul, also some materials will be discussed, we will recover from. Still, there are yet to be recovered some.
Lordship,
And all the branch manager and all taking connivance.
Lordship.
The question is that, let's say Moon Ahmed,
Yeah.
who was also considered to be one of the prime accusers, he is absconding.
Lordship.
So do you think that within 12 or 13 days, will it be possible for the state authority to file their charges? That month is
Lordship.
otherwise materials are there. I have gone through.
Lordship.
And or one petitioner was there also considering only the length of detention that was earlier granted, I think. So far I can remember. And this only question is a 77 days. Within 12, 13, whether it will be possible. Because one absconding is still at home. That is the only aspect. Otherwise, merits are there, available merits are there. It's case of really, I mean, breach of the public trust and all.
Lordship.
So the public deposited their gold in their with an assurance that it will be safe, their gold will be safe, and otherwise those things that happen. That is obviously there. That is the only aspect. If the consideration aspect will be only for the length, no new grounds are there. Absolutely no, nothing is there, and full of merits are yeah. That much.
Lordship.
If we can. Otherwise, by 15th of September, most 90 days will be over. Within 90 days, do you want that any further custodial detention may be required, may not be, I don't know.
Lordship, because there are other goals are there that needs to be recovered, Lordship. And moreover, they have fake customers they have made and
No, these are there.
loan.
These are there. Fake customers are there.
Lordship.
And some portion of the gold most probably yet to recover.
Lordship.
That is there.
Lordship.
I am concerned only with the length of detention. Whether if you can submit that there may be further that then
Lordship.
we can fix it in another day.
Lordship.
These two.
That may be. Otherwise, Lordship, this face-to-face interrogation has to be there, Lordship. Face-to-face interrogation. We are trying our best, Lordship, to apprehend this Moon Ahmed, Lordship. After arresting him, Lordship, face-to-face interrogation has to be there, Lordship. What else? This, Lordship, other petitioners. That is because we need this person, Lordship. Otherwise, they are not revealing, Lordship.
Lordship may impose any condition. I will appear when the Muhammad, if they detain Muhammad arrest, able to arrest, then we may be called, we will cooperate with the investigating whatever the material they wishes, the authority wishes to take from us, my lord. So we will do
Moreover-
conditions, my lord. Only 13 days remain, 7 days and I'm behind the bar, my lord.
Moreover, no new grounds has been there,
I
Lord.
mean, it's a 413, my lord, it's a
Yes,
4,
Lord.
it is not anticipatory bail, my lord. It is section under section 483, I'm application. I'm denied for the last 77 days. They, after calling of this honorable court director to place, sorry, after 18 days, they failed to take up to this case, then my lord, new ground. It is not anticipatory bail, my lord. I'm behind the for the last 77 days. Any condition, my lord, on 13 days remain. Like any condition, like we will regularly we will visit before the authority concerned, my lord, to give a statement. We cooperate with the investigation. If we violate any condition, the bail petition, the lordship and protection, that may be rejected, my lord. If we violate any conditions of this court, my lord, any serious conditions may be imposed, my lord.
Any further submission you want?
No, Lord.
God bless you.
Yes.
I'm for the
33.
petitioners, item number 33, lady lordship. I'm a little bit differently placed because I'm not the employee of the institute where from the gold was misappropriated or trust of the someone people were breached. I'm not from that institute. Assumingly, they have sold, they have given me the gold, and that was invested in the mine institute where I am working. So it was misrepresented by the head of the institute, that Moon Ahmed, and the present petitioner, that those gold were purchased on auction because those gold are from NAP, non-performing asset, NPA. So accordingly, even assuming that I have involved in the case, the offense will be at the trial also, end of the trial, my offense will be receiving the stolen property, because neither I'm associated with the misappropriation of the gold, nor with the breach of trust. My learned friend, he was saying about CCTV footage, passwords, everything. I'm not involved because even CCTV, most probably my footage will not be there. Secondly, even password, because I'm not a employee of that particular institute, so password will not be available. I have only received so far the allegation prima facie. I have received the stolen. Knowing it that it attracts 411 punishment prescribed is 3 years. Already I am almost 72 or 73 days of in custody. Further custodial detention, lordship, that is the main ground, that whether further custodial grant will improve the case of the prosecution. I don't think that hardly 13 or 17 days are left. Further custody will improve the case of the investigation. We are not on merit because already lordship has rejected my petition on merit. So we are not on merit, basically on custody. And my submission is that assuming that I have committed the offense, it attracts 411, receiving stolen property with a knowledge that it has been stolen, that much. I'll leave it to
My learned friend has stated that it's only the knowledge that it part in auction, Lordship. She is also engaged in an financial services, Lordship. She also knows that a bank employees cannot participate in auctions, Lordship. She is well aware of it. So knowledge is definitely there, Lordship. And in her statement, all the person's statements, Lordship, still it is in the investigation stage. 161 can be taken into account, Lordship. So if I look into the statement, she has stated that by giving that she has also received money also, Lordship, not only debt, not only statement, money has also been received by her. If I look into the transactions of the Moon Ahmed, so definitely materials are there, Lordship. She is well involved in the conspiracy, Lordship, and siphoning off this amount, Lordship.
Considering the period of detention, lordship, may kindly allow the lady lordship.
Length of detention is not only the consideration, Lordship. Gravity of the offense also need to be taken into consider.
You were also police custody initially.
Yes. Since 19/6/2025, I'm as on date I'm 71 days.
No, police custody.
For 3 days. For 3 days only.
And you were in police
3 days
custody.
before. Yeah, the police itself demanded the paid for the result.
17. But it's weekend.
In 316 Lordship, life imprisonment is there. Not, so gravity is there.
That's what I'm asking. Do you want to be fix it or order is to be passed, or you want to fix it some more days later?
Okay, Lordship. It can be done, Lordship.
In that case, you again you have
Lordship,
to.
I will get some Lordship, more information about it, Lordship. On
Can it be fixed on Friday? Yes. Otherwise,
No, I think will not be possible. Friday there are lots. 8
already 77 days, most probably.
Right, they think about
11.
Bail petition will become infraction.
yes, 15 is 90 days, my lord.
on 15, 90 days, na?
Yes.
Yeah. No, prior to that, we'll take instruction.
11 Lord.
No, my lord. September, আপনি কেতিয়া আজি কিমান তাৰিখ?
আজি 3
Kindly 8, my lord. Then on Monday 8. If
Monday,
8, not 11, my lord. 8. Our prayer may be
on
considered
10
8.
Lordship then.
8, my lord. 8, my lord.
Lordship.
8, my lord.
Lordship.
So you are going to retain this one, send back this
No,
one?
no, no, we have to send
Instruction
back
only,
it, Lord.
information,
Lordship.
instruction.
Lordship. We have to send back, Lordship, for updating it, Lord.
Then it may not reach.
Yes.
Okay, Lordship, then I will take instruction then.
Only what is the progress in
Lord-
total instruction
Lord,
you take?
I will.
Is there any progress in the apprehending the other accused? Those kind of
Lord,
information.
yes,
you can-
I will definitely.
So that keeping the will benefit them from apprehending the other accused, prime accused. Because what they could not
No,
do
no,
is,
no. What Mr. Das is saying that a face-to-face interrogation may be
Yeah,
required.
that condition may be put.
Yes, lord.
Even after release, we will available for interrogation.
Interrogation.
That
And
is no
only some
problem, no
matters
issue.
may be
Yes.
restricted. But I am on that within, again for say, today is Monday, today is Tuesday. So try Monday, next Monday, whether there is any progress, whether he can be, could have been apprehended or this kind of thing.
Lord.
we can
Let it be fixed on Monday, lots of it.
Lordship.
Much obliged. But
considering 17 and 13 to thank the submission made by that. Let the matter be checked on 8, 9. And the meantime, the CDPD till next set of this, in the meantime, the learned people will take such instructions regarding the apprehension of the, regarding the arrest of the other co-accused, of the prime accused, and other aspects. This second.
Yes, lord.
the-
Lordship may, I will not retain, I will not send back the CD, Lordship, may not observe that, Lordship, retain CD. I will not send it, Lord.
Their observation should not be
Observation
there.
should be not there, Lord.
I have already retaining order. Retaining order, you want the retain order?
Not, no, I don't want the.
Order of retainment.
No, I don't want that, Lordship. I will not retain it, I will keep it. But that observation may not be there, Lord.
Retaining regarding.
Regarding.
No. ठीक है, okay.
Okay.
May I please, your lordship?
Yes.
My lord, item 18, my lord.
18 who is appeared? Some is appeared. Yes, what is 18? Yes,
My lord,
Mr.
this is a regular bail application, my lord. My lord, this is charge-sheeted case, my lord. Earlier, the petitioner approached this court, my lord, by filing a AB, my lord. And my lord, that order is at page, my lord, 41, my lord.
41.
The petitioner, my lord, the charge sheet has been submitted showing the petitioner as absconder, my lord. My lord, they are not FIR name techniques. And thereafter, my lord, on the very first day, my lord, the charge sheet has been received on, my lord, on 39/2024, my lord. On the same day, my lord, the NBW was issued against the petitioner. And my lord, after knowing the fact, my lord, the petitioner approached this honorable court. And your lordship was pleased to direct the petitioner to appear before the trial court by filing a appropriate application. And my lord, Thereafter, they approached the trial court, my lord, by filing application and they were taken into custody, my lord. That is at page, my lord. Page 50.
Can it be taken up after next item, my lord? Just we'll gone through the my lord,
Just perusing.
regarding LCR, my lord. We'll check up the my lord, the status of the my lord. Just after next.
Can PCR has already
Yes,
received.
receipt.
My lord,
Receipt, my
I have my lord, some problem, my lord.
Yeah, yeah, good.
My operation. Without.
আমি কালি করবো আবার থেকে
Tomorrow may not be possible. Tomorrow I have this.
My lord,
from-
otherwise,
medical emergency.
otherwise, yes, my mother is in operation. My lord, otherwise, my lord, there is nothing, my lord. My lord, my lord, they are ready
That
to
is okay, but he
face
wants
the
to pay
trial,
the
my lord.
case for. As per use, there is nothing, but he wants to pay this year, so it needs some time. If you
Let
can
it come
spend
tomorrow, my lord.
tomorrow, not possible. We have some matters from Itana. Already list is over. I mean, list is out already. May not.
No, as per convenient lordships.
Hospital. My lord, title will. Title will. My lord, let it come on Friday, my lord. Friday. Everything is there, my lord.
Friday.
PCR also received.
Friday, but you will be able to do it on Thursday next,
Thursday.
one day
Thursday or-
prior, or if there is any other
Fourth,
medical
fourth.
emergency, then yes.
No, my
Then
lord.
on Friday, then. Okay.
Eye operation, my lord. My mother is going eye operation.
Okay, Friday.
Friday.
Friday is 15th. At the request made by the learned editor, Mr. MP Gusam, please.
Obliged, my lord.
1022, it's up to date, my lord, but I need some instruction regarding the appearance, my lord. So I also pray that let it be next week, my lord, if your lordship convenient, my lord. Otherwise, they are on interim.
Lordship, this
And
case is pending since
You need the
2024.
instruction
Lordship.
regarding their affidavit.
Yes, my lord, because they have sent the up to the city, but
Ah.
it is not reflected regarding their cooperation.
Whether the, just I'll pass the order, but the
Look.
question is that whether the order of anticipatory is available there. See,
No.
whether the anticipatory order of anticipatory, sorry, interim order is
Yes,
available.
yes, it is available, my lord. It
In
is
that
available.
case, some presumption can be taken.
A
that
presumption
interim
can be
is preferred.
taken, my lord. Yes.
Anyway, you take instruction.
Just that is why I am not sending the CD, my lord. Just I'll take that.
At a request made by Learned Edition BP to matter is that list. So next week just we have
Next week,
not of 11
long pending.
11th of September.
Obliged, Lord.
11th of September.
Yeah.
Till then, interim.
Lordship,
continue.
interim may be continued.
Yes, interim may continue till next set of CDPDT. till- What is the position of 21?
My lord, may I please your lordship? Lordship,
21
in
is,
persons to the interim
21
order.
is Having by Mr. Goswami, you are?
Yes, my CD is received, my lord.
Yes.
So we have appeared, my lord, in persons to the interim order, my lord. Before the IO. My lord will please to find the FIR at page 8.
DNA. Yeah, it's with DNA. It's very- Then it were- So you were on interim earlier.
Yes.
They are interim. One is on interim. Only one.
One is on interim.
My lord,
No, no.
one is arrested. He is in interim.
I am for only one petition.
Only one has come. my lord.
Otherwise, there are two accused.
Otherwise,
There were
two accused persons.
One already got arrested.
Yes.
Acha.
My lord will please to find at page 8, my lord, the FIR.
Hmm.
With due respect, I beg to state that today me and my younger brother, after finishing my work, came out of Gossip Sky and Bar for our home, and at the time near ABC Point, two unknown people misbehaved with us and hit us, and as a result of which my younger brother was attacked with a knife and was admitted at GMCH. So I humbly request you to do proper investigation on the matter and provide justice to my younger brother. So here, my innocence will reveal, my lord, from the forwarding of the other accused persons. My lord will please to find at page 14.
Hmm.
Brief facts of the case, my lord. The brief of the case is that on so-and-so, one complainant, so-and-so laws and affairs stating that she is an employee of Gossip Sky and so-and-so, on morning so-and-so at around 4 a.m. when she and her brother were returning home after completing their duty. That time at ABC, two unknown persons were there, and one of them misbehaved them and stabbed their brother, hence the case. So there were two persons, but one of them misbehaved them and stabbed their brother. So it is admitted. Next, reasons of arrest, my lord. The arrested accused person stabbed the victim on his abdomen and made the victim grievously injured. Immediate after the incident, and the victim had to immediately admit to GMCH and so and so, so and so. Yes, he was present, but he didn't do nothing, my lord.
So considering your that submission was fully interim was granted to you.
Yes, my lord.
Interim.
Yes,
My lord,
otherwise.
Yes, he has appeared, he has stated that he has not stabbed him, that is this person, my lord. And my lord, so far medical is concerned, my it is report is awaited, my lord. It is not there. Report awaited, my lord. It is not there regarding medical report. But he received injury because he was stabbed and stitches has to be there in the abdomen, my lord.
So forwarding is very clear. So two persons were there, but one had stabbed, the arrested person has stabbed it. So this person, this petitioner has mere his presence doesn't ipso facto guilty, my lord.
Mr. BFF, okay. Mr. MP. This is an application section switch. To be received, it is subject to that obtaining the order. Let's pray. It 07. He appeared before the eye, cooperated investigation. And his statement is also recorded by the eye. Further subject from the contents of the recording report itself, it seems that the present petitioner committed no such as evident as. However, it is a fact he was present at a relevant. Mr. Deca that the petitioner is still waiting to cooperate. In further if he is provided with privilege of the rest. Next one, submit the learned some that the petitioner had cooperated in the investigation and appeared before the eye after obtaining the order. And his statement is also considering the subject of conducting the investigation. And other aspects of this, I find that custodial interrogation may not be required for the custodial interrogation of the present petitioner may not be required. Hence, the order of interim privilege dated 30/07 is hereby made absolute. Same term.
Much obliged, my lord.
Lordship, Senior Counsel Z Kumar is in another court. May the matter be taken up at 2.
We will try at 2.
My lord.
If the any other matters, and then in that case, I don't know, but otherwise, okay, we'll see.
Obligement.
Because it is a case of 2011 also. Cases of 2011,
My lord,
all pending matter.
I will just ask him once and relate back to the court. Since he's in the court, this was the instruction given to me.
No, at 2 you're saying?
Yes,
We
ma'am.
keep it at 2. Let us see.
Oblige, my lord.
Lordship.
Yes. Who is it? Utsami is like? Yes. Yes.
Yes, ma'am. The incident, some kind of a mercy petition for a simple reason that I being an amicus. I have to be fair to your lordships. 376 acquitted, 336 and 376. Basically, the bone of contention is about the age, because what has now come, your lordships will see, is that the age of the accused, the victim, is what the basis on which 363 has been now posed. So, my lord will just come. I'll just give your lordships a small background. That's it. The incident is of 27th of April 2006, my lord. This complaint is registered by Rameswar Dole, my lord, on 27th of April 2006. The incident is 25th of April 2006 at around 9 p.m. His daughter has come back and complained that the accused has raped her, taken her to a house of PW4, and that she has come back and reported the incident, in the basis of which the Ezahan has come into existence. Now, my lord, in terms of this, there are 7 witnesses who have been examined. 1 and 2 is the father and the mother of the victim. Number 4 is the gentleman in whose house the lady was left, by which the petitioner has left her, abandoned and left her. And the doctor's evidence is PW5. PW6 is the evidence of the victim. And PW7 is the investigating agency, my lord, the investigating officer. Now, my lord, we'll first see what is relevant according to me would be PW5, my lord. I do not have the internal pages of the brief. I am slightly handicapped on this because this is provided to me by the registry. So I don't know, my lord, what will be the pagination.
You want people, I don't know, it's pagination that I don't know, but
I have
want to basically read now doctor's evidence.
Yes.
Doctor, I have flag mark, my lord.
PW5.
Yes.
PW5, man.
PW5.
Yes.
PW5, I have flag mark.
May I read, man? Yes, I'm sorry.
Yes, PW5.
Yes, ma'am. On 27th of April 2006, I was posted as a medical and health officer at so-and-so hospital. On that day, I examined Mrs. Dole, 13 years, on a police requisition on being escorted and identified by woman constable Indra Gogoi and found as follows. Number 1, general examination. Human bite-like mark is found at the right cheek, which is an oval and oblique. On her private examination, found her breast, so-and-so vagina and fully developed. Axillary and pubic hair are scanty. No marks of injury is seen on her private part. Is said to kidnap such minor or person from unlawful guardianship. The
the conviction is under 363, my lord. Here it says whoever kidnaps any person from India or from a lawful guardian shall be punished with an imprisonment of either description in a term may extend to 7 years or shall be liable to be fined. Now this is, we've been convicted for 2 years now. So in terms of this, my lord, the finding is para 8, my lord.
Yes.
The first and foremost point for consideration and ascertain in the instant case is the age of the victim, PW6, at the time of occurrence. Let me consider the evidence on record of the prosecution as to ascertain the age of victim PW6 at the time of occurrence. The alleged incident occurrence took place on 25th of April 2006. PW1 is the father of the victim, and his evidence is that at the time of occurrence, the PW6 was aged about 13 years. PW2 is the mother of the victim, and her evidence is that the time of occurrence the victim, PW6, was aged around 12 to 13 years. It is admitted by PW2 that she herself cannot say about her age. The evidence of PW1 and 2 about the age of the victim of PW6 is not based on any documentary evidence such as horoscope, birth certificate, school certificate, etc., but based on assumption. PW4 is the villager of the complainant, and he has stated that the victim, Monumoti, has been attaining the age of 17 years. But his evidence pertaining to the age of victim, PW6, is not based on assumption. The victim, according to the victim, PW6, at the time of occurrence, her age was 16 to 17 years. The medical evidence of PW5 corroborated with the evidence of victim PW6, and about her age, X-ray was done on the wrist, joint, elbow, and iliac crest for determination of the age of PWD6. The medical opinion of PW5 as regards to the age of the victim is based on an ossification test. According to the medical officer PW5, at the time of the occurrence of the age of victim was more than 15 and less than 17 years. Considering the evidence of the victim of PW6, the medical evidence of PW5, and the documents marked as Exhibit 2 in absence of any documentary evidence such as horoscope, birth certificate, school certificate, it can be inferred that the time of occurrence of the victim, PW6, attained and completed the age of 16. Accordingly, I cannot hold at the time of occurrence PW6 was above the age of 16. Now, in terms of that, my lord, now the point for consideration to be decided is whether the accused had sexual intercourse with the victim against her will and without her consent. It is in this evidence of PW6 that the accused had a sexual intercourse with her or not is on her will and consent. The evidence of PW6 about having sexual intercourse. Yes, ma'am.
Let's talk
Yes,
about it.
I'm sorry.
So basically, so far I can see here. So the case was, the accused was convicted only under section 363.
Yes, only 360.
Only 370.
Yes.
State is not against that. I don't know, maybe there may be reason, but the question is that there was some definite allegation of rape was there or sexual intercourse. was there.
Yes.
Maybe consenting or consensual, whatever.
Yes.
There.
September.
Item 30.
30. Both side is here, my lord.
I
Other
appear for the
side.
petitioner also. He is for the respondent. Let it come up on 18th.
18th.
On 18th.
December, yes.
As per your lordship,
It can be
18th.
18th of September.
Lordship.
The
18th.
Council for Body Practice is met on 18th. Okay. Oh.
DPM.
What did the council? Okay, we'll continue.
Lordship,
Yes.
it's reading paragraph number 9 of the judgment, my lord.
Yes.
Yes, ma'am. Now, the point to be considered and decided is whether the accused had had sexual intercourse with the victim, PW6, against her will and without her consent. That is the question my lord was asking. It is in the evidence of PW6 that the accused had sexual intercourse with her on her will and consent. The evidence of PW6 about having sexual intercourse with her has been corroborated in the medical evidence of PW5. It is in the medical evidence of PW5 that on the medical examination of the person of the victim, Monomoti Dole, he found bite marks on her right cheeks, for which he opined that there was forceful intercourse with her. It was also appears from the evidence.
13. Na? It's a revision.
Revision petition. 1 year and then about 10,000 fine.
1 year and 10,000.
10,000.
Do you want any fixed date or after 2 weeks?
So after 2 weeks,
After 2 weeks. Okay. After 2 weeks. Hard, Mr. Hard.
29.
Eh? Yes, it is item number 20. So we are listing it after 2 weeks as on a date you fixed by registry. Now there is in a process that those which are the old pending ones, we're trying to list it better because today also in my list also hearing this, see 11, 12 and 13 matters are there. So we'll try to dispose of the matter. So 13 after 2 weeks if it is left. Or you can just remind me that it was a leftover on the matter, so that it can be on the priority basis.
There's no,
So we can-
otherwise, Milord, I'm on bail. So, Milord.
Okay.
Replay of that.
Back then, 27 matok any story. Huh? 27 to 28 mark. 28. 29. None of it. After physical. Pooja, you'll be going out and day or you'll be in Guwahati?
I'll be in Guwahati.
You will try. We also having a this big conference of the Legal Services Authority on 11 and 12th of October.
11 and 12.
It will be organized in the Mayfair Hotel, Resort. So we are busy on that matter. In fact, there were yesterday on Friday also one meeting was there. Again yesterday also. So on other records.
It will be during vacation only.
It will be during vacation on 11 and 12. After Puja definitely.
After Puja.
But some of the judges may not be available.
Yes.
Some are